Welcome back to the deep dive. I want you to close your eyes for a second and imagine a scenario that is basically every small business owner's worst nightmare.
Okay.
You spent the last 5 years building a supermarket. And I'm not talking about some little corner store. I mean a full-blown operation,
A serious investment.
a serious investment. You have poured nearly $400,000 into this place. You've taken out loans that make your stomach turn. You've bought industrial freezers, installed all the fixtures. This business, it's your life. It puts food on your table.
And in this scenario, you don't own the building.
Right,
You're leasing.
right. You lease it. But you think you have a safety net. Your contract has a renewal clause that lets you stay for another 5 years. It's right there in black and white. All you have to do is send a letter by a certain date saying, yep, I'm staying.
That's a condition precedent, as we call it in the legal world. A specific hurdle you have to jump over to get the prize.
Exactly. But, and of course there was always a but, you missed the jump. You completely missed the deadline to send that renewal letter, not by a day, but by a whole month. And your landlord, she is not the forgiving type. Why? Because she has McDonald's, the Golden Arches, waiting in the wings. They want to buy the property for double what it's worth, but only if they can get you out.
So the landlord is actually incentivized to catch you slipping up.
Big time. So she sends you an eviction notice, you panic, you call your lawyer's office to scream, why didn't we send the letter? And that is when you find out the tragic twist.
Okay.
Your lawyer, the person whose one job it was to handle these dates, died. He died just 2 weeks before the deadline.
Wow. That is a brutal set of facts. You've got high financial stakes, a missed deadline, and a literal tragedy involving your legal counsel.
So the question we are wrestling with today is simple, but, terrifying. Does the law just say, tough luck, a deadline is a deadline, and you lose your entire livelihood? Or can a judge step in and say, hold on, this is just unfair, and save your business?
What you were asking about is the battle between strict contract enforcement and a concept called equitable relief from forfeiture. It's one of the most interesting tensions in property law.
Equitable relief. It sounds nice, like a warm blanket. But what does it actually mean in the real world?
Well, think of the law as having two brains. One brain is the black letter law. It's cold, it's rigid, and it loves rules. You signed a contract, you missed a date, you're out. End of story. This brain cares about certainty.
Okay.
But then there's the other brain, equity. Equity is the court's conscience. It's the power to look at a situation and say, strictly following the rules here would be, frankly, unconscionably unfair.
So it's the heart versus the head.
Precisely. And today, to see which one wins, we are going to dissect a landmark case from the Connecticut Appellate Court. R&R of Connecticut v. Stiegler from 1985. This case is the perfect storm of everything we just talked about. Dead lawyers, greedy landlords, and massive financial losses.
But before we get to the drama of Stiegler, I know judges don't just flip a coin to decide what's fair. There has to be a standard, right? A rule.
Oh, absolutely. In this jurisdiction, the standard comes from a doctrine known as the F.B. Fountaincourt rule. It's essentially a three-part test, but it has a very scary bouncer at the door.
A bouncer.
I call it the gatekeeper. Before you can even ask a judge for fairness, for equity, you have to pass this one threshold. The rule is equity never helps a tenant who was grossly negligent or willful.
Willful, meaning you did it on purpose.
Exactly. If your mistake was intentional or just incredibly sloppy, the door is locked. You don't even get to argue about fairness.
Okay, so if I'm just a jerk who ignored the contract, I'm out. But if I pass the bouncer, if it was just an honest mistake, what happens then?
Then, and only then, the court starts to balance three things. One, was the delay slight? Two, was the loss to the landlord small? And three, would kicking you out cause you unconscionable hardship?
Slight delay, small loss to the landlord, big loss to the tenant. It sounds like a balancing act.
It is. But that gatekeeper, that difference between an honest mistake and gross negligence, that's where most of these battles are actually fought.
So let's look at the history here. The court in our main case didn't just invent this. They looked at precedents. What kind of delays are we talking about? When they say slight, do they mean like 10 minutes or 10 months?
That's a great question. Let's look at the cases they cited. First, you have the namesake case, F.B. Fountaincourt itself. The tenant there was 4 days late on a 30-day notice.
Okay, 4 days is nothing.
Yeah.
I've had library books overdue longer than that.
Exactly. Then there was Antheki v. Hayes. The tenant was 3 days late, but there was a holiday and a Sunday involved, which, made the whole calculation messy.
Right.
And finally, Galvin v. Simons. That tenant was 13 days late on a 90-day notice.
So we have 3 days, 4 days, and roughly 2 weeks.
Right. And in all of those cases, the court said, okay, this is slight. And more importantly, they ruled that the delay was mere neglect. It wasn't defiance, it was just a slip up. So the tenants were allowed to stay.
Okay, so a couple of weeks seems to be the safe zone. But this concept of gross negligence versus mere neglect still feels a little slippery. Before we get into the Stiegler case, can we make this concrete? Give me a scenario where I'm safe and one where I'm definitely out.
Sure. Let's do some visceral hypotheticals. We'll start with the coma tenant.
The coma tenant. I'm already sympathetic.
Okay, so imagine you have your renewal letter written, stamped, and it's in your pocket. You get in your car to drive to the post office on the day of the deadline. But on the way, a drunk driver hits you. You end up in a coma for 2 days.
Oh, wow.
You wake up, and the deadline has passed.
Yeah, if a judge kicked me out for that, I'd lose all faith in humanity.
And the law agrees with you. This is a classic case of mere neglect or accident. You intended to comply, but something physically stopped you. You passed the bouncer, and equity saves you.
Okay, that's the innocent guy. So who's the villain?
Meet the gambling tenant. Imagine you know the deadline is December 31st. You look at your calendar, you see the date. But you're also secretly negotiating a lease for a cheaper building across town.
Oh, okay.
You think to yourself, I'll just wait a couple weeks. If the new deal falls through, I'll renew the old one late and just apologize.
So I'm hedging my bets. I'm keeping the landlord as my backup plan.
Exactly.
Yeah.
You are gambling with the contract. This is willful, it's strategic. And even if you are only 1 day late, if the court finds out you did it on purpose, equity just slams the door in your face.
It doesn't matter if you lose $1 million.
Doesn't matter. You acted in bad faith.
That is a huge distinction. It's not just that you were late, it's why you were late.
Precisely. And that brings us right back to our Connecticut supermarket owner in R&R v. Stiegler. He's not in a coma, but he definitely doesn't think he's a gambler. He thinks he's a victim of a tragedy.
Right, the dead lawyer.
Uh-huh.
Okay, let's analyze R&R of Connecticut v. Stiegler. First, what are the legally dispositive facts?
Okay, so the lease was a 5-year lease ending December 31st, 1984. Uh-huh. The tenant, R&R, had an option to renew for another 5 years, but they needed to give written notice 12 months prior. So the deadline was December 31st, 1983.
And they missed it.
Completely missed it. On January 26, 1984, the landlord, Stiegler, sends a termination notice.
The get out letter.
Right. Then, on February 6, the tenant's new lawyer writes back with the excuse. The previous lawyer, an attorney Baer, had died on December 14, 1983, and he probably intended to renew.
And what was the economic context here? We mentioned McDonald's.
A huge factor. The landlord had a deal to sell the property to McDonald's for $425,000. The market value was only about $225,000. Meanwhile, the tenant had about $390,000 in loans and $40,000 in fixtures invested in the place.
Wow. Okay. And what was the core legal issue?
The issue was whether the tenant's late notice should be excused on equitable principles. Specifically, did the trial court correctly apply the FB Fountain criteria, especially regarding the degree of negligence?
So what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the FB Fountain Co. rule. It has 4 key parts, but one is a threshold.
Bouncer.
The bouncer. So element 1, the threshold. The failure to give notice must be due to mere neglect, not willful or gross negligence. If you pass that, then you look at the other 3. Element 2, the delay must be slight. Element 3, the loss to the lesser, the landlord, must be small. And element 4, enforcing the deadline would cause unconscionable hardship to the tenant.
Thank you. Now for the court's elemental analysis, let's walk through this step by step. How did the court apply the first element, that degree of negligence?
This was the crucial point. The sub-issue was, did the tenant prove their failure was only mere neglect? Now, the trial court had excused the delay because Attorney Baer died, but the appellate court found that was an error.
Why an error? It seems like a pretty good reason.
Because the new lawyer's statement that he believed it was probably the dead lawyer's intention to renew was, and I'm quoting the court here, completely devoid of any probative value.
Devoid of probative value? That is fancy lawyer speak for it. This proves absolutely nothing, right?
Exactly. It's a hunch, a guess. There were no notes, no draft letter, no evidence whatsoever. The appellate court said the trial court failed to make a specific finding on whether this was willful gross negligence or mere neglect. And without that finding, you can't grant relief.
Wow. So because they couldn't prove what the dead lawyer was thinking, they couldn't pass the gatekeeper. That is cold.
It is. The court basically said you can't just use a tragedy as a blank check.
Understood. Now, what about the second element? Was the delay slight?
The sub-issue here was whether a delay of about 1 month on a 12-month notice period was slight. The court compared this to the precedent's 4 days, 3 days, 13 days, and implicitly they found that yes, it was. The delay was considered slight in the context of the lease.
Okay, so they passed that one. Now, moving to the third element, the loss to the lesser, this is the part that confuses me. The landlord had this huge offer from McDonald's. How did the court analyze this?
This is the most counterintuitive part. The sub-issue was, does the landlord's potential loss of the McDonald's sale, that's a $200,000 profit over market value count, as a loss that prevents equitable relief?
It seems like it obviously should.
Right, but the rule is very specific. The loss must be caused by the delay itself. The landlord must have changed her position during that period of delay.
What does that mean, changed her position?
It means she had to have relied on the tenant's silence. For example, if she had signed the contract with McDonald's on January 15th, during that month of silence, because she thought the tenant wasn't renewing, that would be a change in position.
I see.
But here, there was no evidence she did anything in reliance on the silence. The McDonald's deal was just sort of sitting there. It existed before the deadline. So the court held that the loss of that deal was irrelevant because it wasn't a loss caused by the tenant being late in January.
That is mind-blowing.
Yeah.
So because she didn't actually sign on the dotted line with McDonald's during the delay, that potential $200,000 profit vanishes from the equation.
It vanishes from the equity equation, yes. It was an error for the trial court to even consider it.
Okay, and after analyzing all the elements, what was the court's final conclusion?
The final conclusion was error. The judgment was set aside and the case was remanded for a new trial.
So, sent back down to the lower court?
Yes. The reasoning was that the trial court skipped the most important step, determining if the negligence was gross willful or mere. They said you can't just feel bad about the dead lawyer. You have to analyze the negligence first. You can't even begin to balance the hardships until the tenant clears that first, most critical hurdle.
This has been a roller coaster. For our listeners who are business owners, let's turn this into a survival guide. If I'm facing a problem like this, what's my checklist?
Okay, let's call this the diagnostic checklist. It's a step-by-step framework for analyzing a late lease renewal. Step 1. Check the contract. Is there a condition precedent, a notice deadline? Was it missed? That's the starting point.
Obvious but critical.
Absolutely. Step 2, the negligence gate. This is the why test. Was this mere neglect, like forgetfulness or an accident, or was it gross or willful negligence? If it's willful, you stop the analysis right there. No relief.
So that's the absolute first hurdle.
It is. Step 3, the delay test. If you pass the gate, you ask, is the delay slight? You compare the days late against the total notice period.
Right.
Step 4, the reliance test. This is the loss to the landlord. Did the landlord change their position because of the delay? Remember, a pre-existing deal like the McDonald's one doesn't count unless they acted on the tenant's silence after the deadline passed.
That's the key distinction.
It is. And finally, step 5, the hardship balance. Will the tenant lose substantial improvements, goodwill, their livelihood? You know, like the $400,000 investment in Stiegler. But remember, equity only balances step 4 and 5 if you pass step 2 and 3.
It really highlights the irony here. You can lose $1 million location, a business you've poured your life into, just because you can't prove you weren't grossly negligent, even with a dead lawyer.
That's the harsh reality. The burden is on you to prove that his death caused the error, and that it wasn't just carelessness. In law, almost only counts if you have a really good excuse, and crucially, if you haven't hurt the other partner's position in the meantime. The burden is always on you to prove you deserve the court's mercy.
A sobering thought. Check your dates, people. And maybe don't rely on probably when your livelihood is on the line. That's all for this deep dive into R&R v. Stiegler. We'll see you next time.